continuing our discussion on parties of crimes, I'm going to return to vicarious liability. We talked about it in Chapter 4. What is it? It's when liability is transferred from one defendant to another, and the key is it's based on some special relationship. Okay, defendant doesn't have to commit the criminal act supported by that intent. They just have to be involved with the criminal actor in a legally defined relationship. So that special relationship is going to be outlined by the law in some fashion, as we discussed in Chapter 4. And the primary example of this is employees and employers, where an employer can be responsible for an employee's conduct. I also provided you the example of Napster, the file sharing software that made it possible for people to commit copyright infringement. And when there was a lawsuit brought in criminal charges, the creator of Napster was held vicariously liable, even though he wasn't engaged in actually committing the copyright. It was the users. You see it with the mob or the mafia, right? The higher ups become vicariously liable based on the underlings, what they're doing for them, for their benefit. The two key words: control, benefit, right? Gangs would be the same way. This is, again, like accomplice liability. This isn't a whole nother criminal charge. It's a liability. It's another way you become responsible. You're still charged under the same charge. So if let's take the mafia example, the mob bosses get charged with murder, not because they particularly committed the murder, but one of their underlings was doing the job, so to speak. Okay, so they all have the same level of liability. It is not a separate charge, and that is vicarious liability. When you got to remember, it's based on a special relationship between the two defendants, and that one who's being held liable, even though they didn't commit the act, has some level of control over the original defendant or the defendant, or they tend to benefit in some fashion. And then we have corporate liability. It's different from vicarious liability with employee-employer. Corporate liability is actually a corporation being held criminally responsible for crimes, the actual entity. Because corporations, a little outside the scope of criminal law, but corporations are similar to people. They have all of the same rights as an individual would have. And they can be charged with crimes. Under common law, there was no corporate liability because there was no corporations, right? The government owned everything back in England and so forth. So this is a creation of America. Corporates are private entities, and they can be held criminally responsible for crimes they commit. But do they actually commit the crimes? No, it's usually the people who work for them. What kind of crimes might they commit? Laws they should break, crimes they should commit, I should say. Environmental type crimes, right? Racketeering is another thing, and we'll talk about the RICO Act, where it's the Influence and Corruption Organization Act. It's something that happens under a corporate umbrella, even though it was created to stop the mob. But I'll talk more about RICO when we talk about specific offenses. Tax laws, they break tax laws. But do they go to jail? No, they don't. They don't go to jail. They pay huge, hefty fines. That's how corporations get dinged with their criminal crimes. But those who commit them, how does a corp commit a crime? By the people who work there. I just said that. CEOs, managers, agents, those folks can be subject to incarceration. So a corporation can be criminally responsible for the conduct from its owners or its agents or employees, and it's transferring criminal responsibility of an offense that the agent or employee of the corporation itself committed. And if you want to extend it, it's based on an employment relationship. So technically, you can interchangeably use the concept of vicarious liability as well. It would work here too. You can use vicarious liability or corporate liability. I like to distinguish between the two because I want to show you that corporations can be held criminally responsible, even though they are not an individual. So Harry, an employee of Burger King, shreds corporate docs in his office that could be deemed evidence when Burger King is sued civilly for sexual harassment in a multi-million-dollar case. Harry is charged with the crime. We'll call it obstruction of justice or destroying evidence. Can Burger King be held liable? Yes, they could. Under what theory? You can call it corporate liability, or you can call it vicarious liability. Why is that? Because Harry is a agent or an employee of Burger King, and what's he doing? He's shredding documents that's related to a sexual harassment lawsuit case. Doesn't matter that the Burger King folks don't know about that. The higher ups, let's say a CEO, doesn't know. This is just an individual, like a manager, doing it. Doesn't matter. Like, he wasn't directed to do it, let's put it that way. No, but he's doing it for their benefit. They would get a benefit. So it doesn't matter whether they know or not. He's committing a crime and they could be responsible. How about Brad, the president and CEO of ABC Corp? He is on his cell phone texting while he's driving home from work. And he recklessly hits and kills a pedestrian as he's driving home from work. Can ABC be held vicariously liable for that criminal homicide? I hope you're shaking your head. No, that's kind of obvious. Why? Because he's driving home. He's doing his own thing. He's on his own time. The key to this corporate liability or vicarious liability when we're dealing with this employee-employer, the agent or the employee must be committing the crime during work time, or within the scope of the employment. So let's take the same example, except he's not driving from work. He's leaving his office. He's running a little late to meet a client across town. He's in his car and he's texting saying, hey, I'm going to be late. And this incident happens. He recklessly hits a pedestrian and is driving home. Is that different? That would be different. In this instance, ABC Corp could very well be held liable because he is acting within the scope of his employment. That going to meet a client, even though it's his own actions and his own fault. So what's the? Oh, I think I've already talked about this one. I already mentioned these. I kind of jumped the gun a little bit. What's the punishment for corporations? Big money payouts. They don't get shut down unless they are actually running an illegal operation. If their entire operation is illegal, then they can be shut down. But if they're a corporation doing, let's say, illegal dumping of chemicals in the water, they'll get nabbed for big fines. Maybe they're going to be required to clean it up or pay for the cleanup. But the corporation itself can't be put in jail, as I said. Possibly, depending on what it does, the actual individuals who committed the crime could be. Types of laws they break, already mentioned those. The environmental laws, the tax laws, the securities exchange, the security laws with regards to stocks and things like that are usually high up there on the list. What else do we have? I have two These are two statutes. Well, it's one statute comes out of the state of Connecticut. There's a Part A and there's a Part E. Want to just draw these to your attention. This is going to be this week's forum post, so I'm not going to give you the answer. I want you to look at it. Both of these. Part A, person acting with the mental state required for commission of offense who solicits, requests, commands, impromptus, or intentionally aids another person to engage in conduct which constitutes an offense shall be criminally liable for such conduct and may be prosecuted and punished as if he were the principal. Now I want you to dissect this language, and I want you to tell me which one of the, is this accomplice liability, is this vicarious liability, is this corporate liability, or is it going to be the next one we're going to talk about, which is accessory. And I want you, in the forum post, I'm going to post this all again, including the statutes. You don't have to memorize it, but I want you to think about it. What kind of liability is being imposed here under A? And the same question, what kind of liability is being posted here under B? Person who sells, delivers, or provides any firearm as defined in, and there's a definition of firearm. You don't need to know that. You just got to know what kind of liability we're talking about here, which level of liability. To another person, sells, delivers, or provides firearm to another person to engage in conduct which constitutes an offense, knowing or under circumstances in which he or she should know, that such other person intends to use such firearm in such conduct shall be criminally liable for such conduct and shall be prosecuted and punished as if he were the principal offender. So, decide which liability this is. These two statutes are in that forum post, and I want to give you one more, which this one will be obvious. This one is not going to apply to the examples we just saw, because based on the definition, you're going to know. You're going to figure that answer out real quick. A person who knowingly aids someone who has committed a crime. The key here is when they, for these folks, it's purposely provides assistance and knowing that a crime was committed. So this is after the fact. This is our after the fact. So the laws in the modern view is they've changed that accessory, or that the accomplice after the fact to just an accessory. Okay. And I say, oh, just an accessory, and you'll see why that it's just an accessory. So back to that original example with Rhonda hiding Tom, Mark, and Joe out in her barn. In the original example, does she meet this definition? A person who knowingly aids someone who has committed a crime. So they have to purposely provide it, assistance, and they have to know that a crime was already committed. And the example read for the first time before I changed it, no, because she didn't know. She was away. Yeah, she gave Mark permission to be there, but she had no reason why. And then when she had gotten home and had already learned of the crime, she called the police. So no, she would not be deemed an accessory. But if, on that other example, when I changed it, she knew of the crime and she knew that it was Mark, and the police come to her door and are asking questions, and she's like, I don't know anything about that. I don't know where they are. Afterwards, if it's known, she's going to be charged as an accessory. To the example involving Tom and Mike, where Mike is going to his ex's house, they get into an argument, and he pushes her inside. There's a gunshot. And then afterwards, he runs out of the house, yells to Tom, drive, and he does. And then they go to their house, Tom's house, and they work out their story. That could lead Tom to be charged, maybe not with accomplice liability, but with accessory liability. So accessory liability is after the fact. It's certainly still around. You see it in charges like obstructing justice, hindering prosecution. It's actually charged as a separate offense in those two examples in New York State I just gave you. Is obstructing governmental justice when you are not, if you're hiding somebody out in your house and the cops are coming to look for them. Nope, I don't know where they are. That's an example of it. Hindering prosecution, you're hiding evidence, destroying evidence. This is actually a lower level offense. Most states it's categorized as a misdemeanor. However, if we're dealing with you destroying someone destroying evidence or helping somebody escape, that could be elevated to a felony. So it could be a felony, but it's its own separate charge. It's not, oh, you're an accessory to this bank robbery, so we're going to charge you with bank robbery because you hid them out after the fact. There's no equal weight in the charge. I just want to go through the elements of the offense. I unfortunately don't know why I don't have a slide for it, but I don't have a slide for it. The criminal act. So the criminal act to be an accessory is you're aiding or assisting in escape or concealment or invasion of arrest, or aiding and assisting in evading a prosecution or a conviction. And a keynote here, just on the side, you cannot be an accessory to a misdemeanor. It doesn't count for a misdemeanor. It would have to be a felony. So the principal is committing a felony. Words can be enough. Words can be enough. Yeah, no, officer, I don't know where they are. I'll let you know if I find anything out. Thanks for stopping by. And they close the door, and the principal is hiding behind the door as it's open. That is enough to get someone an accessory charge. The intent, you must act with the general intent or the knowledge that the principal committed the crime. And you must purposely help or assist that principal escape, evade arrest, or avoid prosecution. Okay? I think that is it on accessory. Like I said, it's a lower graded offense. Obstruction of governmental administration. And another one is called facilitation of such and such a crime. They'll have it by the name of the crime. That's in New York. But like I said, it's a lower level offense. It's either a misdemeanor or it's a low level felony. So those were our parties to a crime. Remember to do the forum post on the Connecticut statute that we just kind of reviewed. And next week is inchoate crimes.